Welcome everyone to today's webinar on Startup Essentials for Co-founder and Shareholders Agreements. My name is Sarah Roberts and I'm joined today by my colleague Robert Chen, and we're both lawyers in the corporate and commercial team at LegalVision. Before we begin, we have a few quick housekeeping items to take care of. Following this webinar, we'll email you a copy of the webinar recording, so don't worry about taking too many notes. We'll be taking some questions at the end, so please submit your questions throughout the session in the chat box at any time. And finally, we'll send through a survey after the webinar. We really appreciate your feedback, so please fill it out. Turning now to the contents of today's webinar, we're going to be discussing the fundamental legal matters for startups like yours to consider. In particular, we'll be looking at the benefits of the corporate structure. We'll then have a look at what exactly is a co-founder agreement and when it can be useful. We'll then look at what a shareholders agreement is and some of the key clauses that you should be aware of. Finally, we're going to go through an overview of your corporate governance responsibilities. To get us started, Robert will now speak about the benefits of a corporate structure.
Thanks, Sarah. So there are many ways in which you can have a corporate structure, and one of the more common ways is to have a company structure. But we should probably ask ourselves the question, what is a company? A company is a legal entity which is separate from its members, and it's a bit of a strange concept to wrap your head around. They're intangible things created by humans, they're abstract creations, but they're considered and recognized under law as legal entities and as, believe it or not, a natural person. So being a separate entity, its assets and property belong to it, that is to the company and not to its members. So any revenue that is generated by a company is not owned by its directors, but is actually owned by the company. Keeping in mind that a company is a natural person, what this means is it can buy or sell assets, and it can also sue and be sued. So in a similar way to how people get birth certificates registered when they are born, companies when they are born and registered need to be registered with the Australian Securities and Investments Commission, otherwise known as ASIC. So when you combine the concepts of legal personhood and the separation of the company and its members, what this means is its members are able to enjoy limited liability. What does limited liability mean? Well, the concept goes as such. The company is liable for its own actions and inactions. Its members, meaning its shareholders and directors, are not liable for the actions of the company. They are generally liable for the amount they are required to contribute or pay into the company, but otherwise they are personally shielded from any liability of the company because of this concept of the company being its own person. What does this look like practically? This means that if there is a claim against the company of which you are a shareholder in, it is likely that, say, your house won't be at risk of being possessed, the funds in your personal bank account won't be seized under a court order. Instead, what you enjoy is what we call limited liability. There is a catch to this concept of limited liability though. So as a director, you can potentially be personally liable if you breach your director's duties, which we will get into later. So moving on, one of the primary benefits of using a company structure is that as a member or director of a company, as I touched on, you have this layer of protection, which is the company, which kind of insulates your own personal assets from business's assets and liabilities. This makes it cleaner for many reasons. So operationally, an example of that is you don't entangle your own personal funds with the company's funds, you keep them separate. Companies are also a more attractive structure for investors as opposed to a sole trader or a partnership structure where you can be personally liable. One of the many reasons why investors will choose a company structure is because companies have corporate governance and management frameworks in place which flow through from the legislation to the key company documents, such as the Constitution and the Shareholders Agreement, which Sarah will dive into further detail. In contrast to a sole trader or a partnership structure, there are multiple exit strategies available to shareholders in a company. So many founders launch their startup with the goal of eventually exiting the business and generating a capital return. Others don't. It's fine, their startup is their life's work. Although we can be sure of one thing, every investor invests in the startup to generate a capital return. So you then need a plan for a future liquidity event of some kind. The three options commonly available are: one, a business sale, so either by way of an asset sale or a share sale; two, an initial public offering, otherwise known as an IPO; or three, an existing shareholder or a third-party investor buyout. So using the company structure, there's also better succession planning for the company and business to continue if circumstances change. So for example, if a shareholder dies, the shareholder agreement will cover that process of what happens to that now deceased shareholder's shares. What this does is it helps minimize uncertainty for the business operations and reduces the risk of ownership disputes. One of the other popular benefits of using a company structure is that you get taxed at a corporate rate. Quick disclaimer, not a tax lawyer, but we do have tax lawyers available who are able to assist you. As a sole trader, the downside of operating as a sole trader is you could potentially be liable to pay tax at the individual tax rate, which is a lot higher than the company tax rate. You also have the option to have a discretionary trust as a shareholder of the company. This could potentially allow you to stream income in a more tax-effective way. And finally, having a company structure also gives your company access to government R&D grants, early stage innovative company incentives, and many more. But zooming back out, we do need to get into the nuts and bolts of what is a co-founder agreement. And with that, over to you, Sarah.
Thanks, Robert. Many of us will know that a small team, such as 2 people, is often considered the best number of founders for a successful startup. But not all co-founders live happily ever after, with estimates of between 35 to 45% of all startups breaking up. And it's understandable that a lot of businesses started up by a small number of founders end up breaking up. Oftentimes, founders haven't been working together for that long, cash is limited, and the hours that they're working are really long. All of this exacerbates any challenges that the founders might be having in relation to the business strategy. For this reason, a co-founder agreement can be a good idea. A co-founder agreement is an important document for startups to help prepare founders for what the future might hold. The purpose of the co-founder agreement is to set out the rights, responsibilities, and obligations of each founder. It establishes the rules in relation to the business's everyday operations. It can be used to describe the project or projects that a business might be working on and the responsibilities held by each founder in relation to that project. It'll also often regulate matters that are not typically considered by a company constitution. A co-founder agreement is often a place as well where the founders might detail their initial capital investment that they've put into the company, as well as other types of contributions, such as property or services. A co-founder agreement might also include a vesting arrangement, which we'll talk about in a little more detail later in this presentation. Turning now to what exactly is a shareholders agreement. A shareholders agreement is a legally binding contract between a company and its shareholders and between the shareholders and each other. The shareholders agreement is arguably the most important document that you can enter into to ensure the most success for your business. Why is this? Well, because a shareholders agreement will provide extra peace of mind that everybody has agreed on how the company is to be managed and what input key stakeholders will have. The shareholders agreement will detail the way in which directors are appointed and how they can be removed, what specific matters need to be decided by the directors as opposed to what matters need to be decided by the shareholders, and which items require a special majority approval, which is 75% of the directors or of the shareholders, and which of those issues only require an ordinary resolution. This is a 50% approval. Or which items need to be decided by a unanimous decision. This means that the board will properly oversee any major decisions. Your shareholders agreement will also cover important procedural matters, such as board meetings and how they're run and shareholder meetings. It can also impose restraints on the shareholders to not compete with the company in the event that the shareholder leaves the business. Later in this presentation, we'll consider other key concepts included in a shareholders agreement, such as exit strategies. All of these factors can be quite difficult or uncomfortable to discuss with the founders at the outset. But it's a great way of trying to manage the shareholders or the founders' expectations from the beginning, which all in turn helps protect against dispute risk. Robert is now going to take us through some of the duties and responsibilities which are specific to the role of director.
Thanks, Sarah. So as she's rightfully mentioned, a shareholders agreement sets out the rights and the obligations in relation to the board of directors and shareholders. But ultimately, it's a governance document. So let's take a step back and ask ourselves, what is a board of directors? What's a director? Well, a director is someone who is appointed, typically by shareholders, to carry out the executive functions of managing and administering a company. And the board of directors, well, it's just a group of them who get together to do just that. They make important decisions about how a company is operated on a day-to-day basis, but also the critical business matters, such as deciding on a business plan and budget, how much capital expenditure can be incurred by the company, say in the next financial year, any disputes that the company might find itself in, and other things like your accounting practices. So when it comes to developing and implementing the strategy for a business, the board of directors plays a key and vital role. And that's why there's a link to the shareholders agreement being the right to appoint directors to the board. The shareholders are the ones who elect directors to the board, which is why there's a lot of importance attached to that particular contractual right in the shareholders agreement. So moving on, I think the key takeaway is to appreciate that directors have legal duties, which are these prescribed behaviours and rules that a person must follow when they are acting as a director or a shadow director of a company. And they have these duties because directors are in a unique position of power and trust. They make decisions that affect shareholders' capital and the value of those shares. So these duties are substantially laid out in the corporation's legislation. But what we'll do now is we'll take a look at some of the examples of what these duties may look like in your day-to-day business to give you a good idea of what to look out for. So the first one is to perform your duty with care, diligence, and skill. Now, this duty exists because a director is basically in charge of your business's day-to-day operations. They make decisions, quite important ones, on behalf of the shareholders who are contributing capital and own the company. So as a director, you need to stay informed of what is going on in the company. For example, if you've sold a company asset for less than market value, for example, and you haven't done your research on how that asset's actually valued or priced that in the relevant market, then you could potentially be in breach of this duty. Or if you're taking out, say, an insurance policy for your business and you don't read your insurance policy through, or obtain advice from a broker, then you end up taking out the wrong insurance that's not fit for purpose for your business, then you could be in breach of this duty as well. The next one is to prevent insolvent trading. So a director needs to prevent a company from trading while it is insolvent. A company is insolvent when it can't pay its debts on time, in which case you need to make sure that the company isn't trading, quite importantly. So for example, if you notice that the funds in your business bank account are dipping pretty low, and you've got a scheduled payment next week for, say, Google advertising, you can't meet it, then you're in a bit of hot water here. You might be in breach of this duty. Next one is to act in good faith in the best interests of the company. What does this actually mean? Well, you need to make decisions that benefit the company, even if they don't benefit you. So you must avoid situations where conflicts of interest may exist, as well as manage those conflicts when they do arise. So for example, if you've applied for a government program for small business assistance, and for one of the requirements, prerequisites for funding is you need to take out a certain type of insurance. but that insurance isn't compatible with your business model or isn't required, you take out the insurance anyway to meet the funding requirement, then you could be in breach of this duty. Now, the previous example kind of leads well into the next one, which is the duty to not use your position or access to information to gain personal advantage, because it could potentially be a breach of this one as well. What does this mean? Well, you need to prioritize the company's interest over your own. Now, another example of where you could be in breach of this duty is if, say, you use confidential client information and you go and set up a competing business down the road. Another one is you can't contract with your brother's business or your uncle's business for supplies if there are better alternatives and prices available. And finally, companies need to keep records and prepare financial reports. What does this actually mean? Well, you need to keep written records of your directors' meetings, the resolutions passed, the contracts the company is entering into, that's employment contracts, lending, like loans, facilities, profit and loss statements. You're going to keep records for 7 years, store them electronically. Some of the other records you might want to consider include, say, invoices, receipts, checks. So I guess that brings us to the end of that. But if you do end up breaching, so if a director ends up breaching their director's duties, you can get into trouble. So you can be potentially fined. Directors can be disqualified from managing a company in the future, or even held to be personally liable to pay off the company's debts. And this could be to creditors, suppliers, lenders, and even employees. And in the worst cases, criminal penalties may be applied. This is generally if, say, a director's acted dishonestly or recklessly. An example of dishonest conduct could be lying about the company's financial position to a supplier who then provide the company with a lot of goods that the company could not end up paying for. So I guess moving on to the internal management frameworks you can adopt. This is quite important because I think if you're joining this webinar, chances are you're either a founder, co-founder, shareholder, or even investor. But what's really important, and this is a common thread which runs throughout this entire slide, including the documents which Sarah touches upon, good corporate governance is really important to a company's health because it reduces internal and external risks. It fosters a strong culture of integrity, which can lead to a positive performing and sustainable business. Now, it also signals to the market that an organization is well managed and the interests of management are aligned with other stakeholders. So it can potentially provide business with a competitive advantage. Now, if you're anything like me, you're still, when people talk about corporate governance or similar other buzzwords, you're probably wondering, well, what does it actually mean? Can you give me a few examples? Corporate governance, simply, conceptually, it's a system of policies, processes, and rules that direct and control a business's behavior. And these systems, policies, processes, and rules and laws often overlap to a degree. It's the framework that defines the relationship between shareholders, management, the board of directors, and other key stakeholders. And these are the layers of governance available, which I'll discuss, beginning with the written law itself. So it's the Corporations Act that is the overarching legislative framework which governs companies from, like I mentioned earlier, the birth of a company, you got to register it. Directors' duties, what you can, can't do as a director, determining what is a private company, what's a public company, what are your reporting requirements, and to assist you with your ongoing operations. The Corporations Act contains the replaceable rules. These replaceable rules are a minimum standard for the internal management of a company. They're the basic rules which form the minimum standard which you must adhere to under law. They're called the replaceable rules in that those provisions in the Corporations Act can be displaced and modified by your company's constitution. So one example is that, say, a director of a company may resign as a director of the company by giving a written notice of his resignation or her resignation to the company at its registered office. You can modify that to say it can be done via email. Now, another one could be how do you issue shares? Now that's contained in the corporation in the replaceable rules, where say directors must offer shareholders the first right to purchase new shares if they have the existing class, if they're of the existing class of shares. Now, like I said, these rules can be amended and modified in the Constitution. The Constitution is a document which usually includes the organisation of company meetings, execution of company documents, rights of shareholders, the appointment powers and removal of directors. How does that all work? And the process of amending the Constitution. And then finally, it flows down through to the Shareholders Agreement, which governs the rights and responsibilities of shareholders and directors. And then typically when there's any inconsistency between the company's constitution and the shareholder agreement, the shareholder agreement will typically trump the constitution. That in a way ties together all three of those layers of governance and how they work. So at LegalVision, we can assist you with working through those documents and how to prepare them so that you will have documents which speak to each other and aren't inconsistent with each other as well, which can be problematic. Now I'll hand it back to Sarah to discuss the shareholder agreement in further detail.
Yeah, thanks, Robert. We're now going to dive into some of the kind of key concepts which are typically included in a shareholders agreement. The first one being the selling, buying and issuing of shares, and this one's quite significant. The shareholder agreement will typically set out the way in which an existing shareholder can sell or transfer its shares. It is standard for a shareholders agreement to include a preemptive rights procedure. This requires an existing shareholder who wishes to sell their shares to first offer their shares for sale to the other shareholders in the company in accordance with a prescribed timetable. If other shareholders elect to waive the right to purchase the selling shareholder's shares, the selling shareholder can offer their shares to third-party investors. A similar process is included in the shareholders agreement relating to the issue of new shares. When a company wishes to issue new shares, then the existing shareholders have preemptive or a first right to apply for and to purchase the new shares before those shares can be offered to third parties. These rights are beneficial to shareholders because it can help limit their ownership from being diluted. It also prohibits from one shareholder from unilaterally issuing shares to themselves or to another person. We'll now take a look at what exactly a drag-along and tag-along provision is. Drag-along and tag-along provisions are a great example of the balancing act between the rights of majority shareholders and those of minority shareholders. A drag-along clause gives the majority shareholders the ability to require the minority shareholders to sell their shares in the event of a takeover. The drag prevents minority shareholders from essentially blocking a sale of the entire company. For example, if a larger, maybe even public company wishes to purchase the entire company, the majority shareholders holding more than 75% of the company can agree to sell their shares. In this scenario, the majority shareholders can drag along the remaining minority shareholders and require for them to sell their shares. This means that the larger company can purchase the entire company. Whereas a tag-along provision will enable the minority shareholders to tag along with the majority shareholders to sell their shares for the same price and on the same terms and conditions as the majority shareholders. The thresholds that activate the drag and tag-along provisions will vary and should be considered in light of your current ownership as well as your potential future ownership. Turning now to what a shareholders agreement might say about ESOPs, or an employee share option plan. An ESOP is a scheme where you can offer your employees or contractors options in your company. The purpose of granting options to key people in the business is to incentivize those people to stay working for the business for a longer period of time, and or to keep them engaged by giving them ownership or at least a sense of ownership. Before you issue options under your ESOP, you need to get shareholders to give their approval. It is best and most efficient if you get your shareholders to pre-approve issuing options under your ESOP up to a certain amount. Your shareholders agreement can contain this pre-approval. Essentially, the shareholders agreement will include a clause enabling the shareholders to pre-approve the issuance of shares to future employees or contractors under an ESOP, without the need to seek further approval from the shareholders each and every time that the company wishes to grant options or to issue shares under that ESOP. Typically, this pre-approval will establish a maximum percentage of shares in the company which can be issued under the ESOP. And between 10 to 20% is common for early stage companies. This pre-approved amount will be known as your ESOP pool. As I said earlier, we'd look at what a vesting clause is and when it can be included in co-founder and shareholders agreements. So just turning our minds back to what is vesting. And under a vesting arrangement, a vested share is one that you can act on and sell, whereas an unvested share is one that you own, but you can only act on it and sell after a period of time has passed or an event occurs. If you leave the company before the vesting condition has occurred, you will forfeit your shares and have to sell them back to the company for their nominal value. Many startups use share vesting to incentivize founders and key employees in their startup to stay committed to the business. Sometimes founders will agree to a share vesting arrangement to encourage each other to work at the startup for a minimum period of time. Plus, if one of the founders were to leave the business early on, it may not be fair for them to keep such a large percentage of the company. Time-based vesting is the most common way that shares vest, often being used because it is a straightforward and objective measure. It is quite routine to introduce these share vesting arrangements in shareholders agreements, particularly for founders, but it's also commonly found in a co-founder agreement, or you could have a standalone vesting agreement. Robert is now going to take us through some of the practical tips on managing your corporate governance.
Thanks, Sarah. So I'll just quickly wrap this up with some practical tips. And the sooner you implement these tips, what we consider to be best practice, the better for the reasons I mentioned a little bit earlier. So it helps with the business model, it's more attractive for investors, helps keep you out of trouble with regulatory authorities, which is always handy, and it just helps run the company like a well-oiled machine. So company books, we've got registers and meeting minutes. Companies are going to need to have company books. In fact, it's actually legislated, or it's a requirement under law. Companies have to keep certain records, registers, books. Now, the three registers that must be kept by a company are, one, the members register. This one's really important. It must be updated when shares are dealt with. So it deals with issuance of new shares, the transfer, when you sell shares. It's a register, it's a live document that needs to continue to be updated. And it's the source of truth in relation to a company's shareholdings. The next one is a register of anyone who has an option over unissued shares. And then thirdly, you need a register of debenture holders. When it comes to registers, it's really important to maintain them. We can work with you on the specifics, but the key thing to note here is you need to keep constantly updating them. And if you don't, you could potentially be in hot trouble with ASIC, and it could even lead to shareholder disputes internally. With meeting minutes, there are rules around meeting minutes as well as to when you need to record them, what typically goes into them. But generally, proceedings and resolutions, the decisions that are past meetings of company members or directors' meetings, they need to be recorded in the company's minute books within a month of the meeting. Now, if you pass a resolution without a meeting, that also needs to be recorded in the relevant meeting book within a month as well. So some of the things you might look to include in your meeting minutes, I'd say, like your date, time, place of meeting, who was there, who wasn't there, any conflict of interest declared by a director, so the chair, the quorum, meaning how many people showed up, background, resolutions, and then the signature of the chair as well. Now, when it comes to signing company documents, this is really important because if you have someone who's signing a document and doesn't have the authority to sign that document, then that document may not, potentially could be unenforceable, won't be a binding agreement. So important thing to note is an individual who acts with the company's authority, whether that's in the form of the Constitution. So the Constitution can set this out as to who's got the authority to actually sign on behalf of the company, or this could be set out in a company's delegation of authority manual. The reason for this is because traditionally contracts require wet ink signatures. They need to be signed paper, pen, wet ink. However, times are changing. Due to the advent of COVID for the last 2 years, laws have been passed. We have been able to sign electronically. And now laws have again been passed, and this is now a permanent fixture. So you can continue to sign electronically, whether it's split execution, but you need to make sure that certain criteria are met, and we can help you meet that criteria, which then ensures that you're signing a contract that is binding. So with meetings and voting, the Constitution and Shareholders Agreement will be the two documents that usually set out these provisions as to notices of meetings, the procedure at meetings, when the meeting's meant to be held, and similar matters. So you need to make sure that when you do go through your Shareholders Agreement and Constitution, make sure that these provisions are there, and make sure that they fit and work for your organisation and are practical. And like I touched upon with the new laws around electronic execution of a contract, similarly, you can now hold electronic meetings. So you can use technology, but you can use Google Meet, you can use Skype or whatever it is you want to use. But the key thing to note here is that whatever technology you use, you've got to give the persons who are entitled to attend the meeting a reasonable opportunity to participate without them actually being physically present. Now, finally, this is something I touched on as well a little bit earlier. The company must keep written financial records. In fact, it should keep more records than not. And these records should correctly record and explain transactions, the company's financial position and performance. The more in writing, the better. It helps reduce disputes. If you forget something, well, it's there in writing. So record, but I guess do it with a proportionately to how important the things are that you are recording. Now, that brings the practical tips to an end, and it also brings a formal presentation to an end. And so Sarah and I hope you all have found this very useful. But before you go, make sure you download our startup manual. It's one of our most popular and downloaded manuals. It's completely free. It's got tips, it's got tricks. It's really easy to access. I think you can just, there's something in the handout section in your webinar panel, you can just start downloading it. So check it out.
Great. Yeah, we hope you enjoyed today. We run these webinars all the time, and we have lots more coming up. One of the ones that we're most interested in watching ourselves is this one coming up on the 7th of April, I think it is, and it's everything you need to know about SaaS agreements. So check that one out if you're interested.
Awesome. So as promised, we've got a Q&A section, and we've got some really, really good questions coming, Sarah. And let's see here. We've got, so the first cab off the rank. I think, Sarah, this one will be for you. So the question is, my co-founder said a shareholder agreement is good enough. Do we need another co-founder agreement then?
Yeah, that's a really good question. And I think that your shareholders agreement should be sufficient, as long as it includes some of the important founder protections that we've discussed today, such as the ability for founders to be able to appoint a director, and for them to be present at any directors or shareholder meetings, vesting, that type of thing. The shareholders agreement is usually more all-encompassing than the co-founder agreement, and the co-founder agreement is oftentimes more of a preliminary document put together between a couple of initial founders with the intention to then enter into a more all-encompassing shareholders agreement when you're getting third-party investors to come on board. So it should be sufficient. However, we would always recommend that you get your shareholders agreement reviewed by a lawyer to ensure that it most adequately protects you. And of course, LegalVision can assist you with that. Okay.
Nice.
Have a look at what other questions are coming through. Robert, I think we've got one here that maybe you could answer. It is, when does director's duty start? For example, this person bought or registered their company, so they got an ACN, but they haven't done anything else yet.
So the company's been registered. I think you do also have to then inform ASIC that you are you are a director and be a registered director of that company as well. As soon as you start, I guess, operating your company from incorporation, your director's duties will commence. And I think there's not really.
Yeah, typically when you register a company with ASIC, you have to appoint a director at the same time. So it's likely that your director's duties have already commenced.
Exactly.
Yeah.
Nice. Well, we've got another one here, Sarah, which is, so I have an MVP that needs considerable funding. With regards to shareholders and co-founders when attracting investors, what share of the company would they be looking for?
That's a good question. I think, every deal is different, and it's ultimately a commercial decision as to how much, your third-party investor is willing to pay, what your company is valued at, and therefore then potentially what percentage they could take up, and also what percentage you're prepared to give away. I think it's important to remember that a special resolution of shareholders or of directors is at least 75% of those directors or shareholders. So if you're giving away more than, terrible at math, 25% of the company, then you will be losing a little bit of control when making decisions where a special resolution is required. So I think that's important to keep into consideration.
Nice. We've got one here. This is one I mentioned throughout the presentation. You mentioned 3 registers before. One was the members register. What were the other 2? So the other 2 were, the register was for the ones, the debenture holders, and people who have options over unissued shares. So those were the other 2.
Okay, good. Do you think we have time for just one more? I think we do.
I think we do. We've got one here. I'm happy to take this one, or if you want to take this one, Sarah, that's totally cool. How do I bring in external investment without losing control of the company?
Yeah, happy for you to answer that one.
Yeah, no worries. So, there are a number of ways which you can inject investments or funds into a company. So I guess first point of call is it's worth talking about the options specific to your business with a lawyer or an accountant or a financial advisor. But if you're looking to take money from an investor in return for shares, then you'll find that your founder's shares will be diluted to an extent. And we can help you understand what kind of dilution is market standard, specific to your business, specific to its size, the time it's spent operating, valuation, which industry it's in. But there are decisions you can make early on to help protect the founders. For example, you can include certain provisions in your shareholders agreement, which gives the founders an entrenched degree of control, such as the automatic right to appoint and remove a director, and or be present at board meetings and shareholder meetings. And I think the other thing to keep in mind is at a high level and conceptually, whenever you have an investment coming in, chances are you're going to have to relinquish some sort of degree of control, whether it's in the form of shares, and as you know, with the issuance of new shares, typically there's a degree of control being relinquished in that the entity with the new shares will also have some voting power. And so some of the markers, like Sarah's mentioned in her slides, to be aware of are 75% required for members' votes for a special resolution to be passed, and then 50% for a ordinary resolution. So those are some of the markers you can keep in mind as to how much investment you can accept and how do you manage that degree of control over the company. So I think that's it. So I think that's all we've got time for. There's heaps of good questions come in. Unfortunately, we can't take them on this call, but look, you can always get in touch with us. There's an email address which you can email. I think it's reply@legalvision.com.au. We do need to move on to the LVConnect Pro membership. So what this is it's by popular demand by our clients. A lot of our clients have now shifted to this model. It's basically an all-you-can-eat legal needs business model where you pay a flat fee on a monthly basis, and you get access to what you can see on the screen: unlimited document drafting reviews. That's sending your contracts, we review, we talk to you about it, we make amendments. We've got unlimited legal advice consultations, employment, HR, and support. It's a really proactive way of looking at your legal needs, and it provides you with cost certainty as well as legal certainty. So anyone who attends this webinar is eligible to receive a complimentary consultation to discuss how this model can work for your business and redeem a special offer. And if you aren't satisfied, then within the first 30 days, then feel free to cancel your membership. We'll leave it at that. Sarah, did you have anything else to add to that?
Yeah, just I guess one other point. There are so many good questions coming through, and they're all types of things that we regularly assist our clients with in their unlimited legal advice consultations that they have access to as part of the LVConnect Pro membership. So if these questions are coming up for you, it might be worthwhile reaching out. So to book at one of these complimentary sessions and redeem your special offer, all you need to do is click yes in the survey that will appear after the webinar and leave your contact information, or send us an email to reply@legalvision.com.au and mention that you attended the webinar. Great, I think that's it for us. Thank you all so much for attending today. It was great to have so many people, and we look forward to hopefully speaking to you again soon.
Thanks, guys.